Hello, I am Surya Subedi. I am Professor of International Law and the author of the study guide on international investment law. And today I will talk about the content, what the course covers in section C of international investment law course that you are studying. Section C is designed to examine the evolution of bilateral investment treaties, the content of bilateral investment treaties, the reasons why states conclude bilateral investment treaties, and what is the recent trend in negotiations for bilateral investment treaties. In the absence of a global comprehensive convention on international investment law, much of the international investment law today is based on bilateral investment treaties, and there are nearly 3,000 of them. If you include other bilateral treaties which also have some aspects of foreign investment, then we are talking about even 5,000 or so treaties, but bilateral investment treaties themselves are about 3,000 today. How these treaties, why the notion of bilateral investment treaty was conceived, what was the character of the first generation of bilateral investment treaties, and what is the character of the recent cases of bilateral investment treaties. That is the focus of this section. I have examined the origin of bilateral investment treaties. The first ones concluded in the late 1950s, and the number accelerated rapidly in the 70s and 80s, and basically mushroomed in the 1990s and the last decade 2000s. Because very many states, especially the developing ones, which did not have a very well developed of legal system or their own laws designed to attract foreign investment. Foreign investment has played a very crucial role for a long time in the development of developing countries, also developed countries, because foreign investors bring in a much needed foreign capital, technology, know-how. Very many developing countries are sitting on a vast amount of natural resources, but they do not have the capacity to exploit or to harness the natural resources that they have. They need capital, they need technology, they need managerial know-how to harness the natural resources they have to uplift the standard of living of the people within the country. So, when they are looking for different options, one of the attractive options for them is to attract foreign investment, money, capital, managerial know-how and technology. To do that, you have to offer some incentives. If you come and invest here, first of all we will guarantee that your investment is secure. Second thing, we will guarantee that you can transfer the profits you have made back to the country of your origin. And third thing, should something go wrong, of course government change through elections, through various other means. Once you have gone to invest in a country at the invitation of a particular government, in 3-4 years time that government is no longer in power. How do you make sure that the investment, for instance acquiring land or investing in big infrastructure related projects, you cannot just leave the country, take your assets away or back to the country of your origin, because your commitment is a longer term. Investing in hydropower projects is a long term investment. You have to be in the country for a long time. You have to wait long enough to make any profit, but in the meantime, should the change of government affect your investment, what are your options there? How can you make sure that you are properly compensated? How do you make sure that you are treated fairly and equitably when you are doing business in that country? You go on to do business in that country, you do either in the form of a subsidiary company or establish a branch office or different other forms of doing business. but whatever form you adopt, if you have invested in that country, you should be protected by the law, both national and international. When we say international law, then of course bilateral investment treaties come into the picture. Therefore, over the last 30-40 years, the number of bilateral investment treaties has increased, and they are the main source of protection today for foreign investors. They want to rely on, for instance, if you are a foreign investor, for instance from Japan, intending to invest in say Thailand, the Japanese companies which will actually be investing would like to see a separate bilateral investment treaty concluded between Japan and Thailand, so that should something go wrong, they can rely on the bilateral investment treaty, first of all to seek protection, first of all to argue that they have been treated unfairly, and to make sure that a dispute arising out of the application or interpretation of the bilateral investment treaties can be taken to an independent neutral mechanism. If you are going to sue the government of Thailand in the courts of Thailand itself for a number of traditional reasons, first of all the judiciary may not be efficient, may not be able to dispense speedy, effective and impartial justice for a number of reasons. Therefore, foreign investors have always insisted on having a mechanism to settle disputes outside of the jurisdiction of the country. When there is a dispute between a foreign investor and the investor receiving countries, you must be able to take the dispute out of the country to an international tribunal and get effective legal remedy. That is why bilateral investment treaties have been very important in assuring foreign investors that these are the principles under which you will be protected. Should something go wrong, this will be the mechanism you can resort to. So, providing an additional but very important layer of protection for foreign investors, so that those which companies and business organizations have the ability and capacity to invest in other countries can invest, they benefit by making profit, so that they can invest elsewhere or reinvest. Those countries which receive foreign investment benefit from it, but when this type of business activity takes place, there is always a downside to it. How to make sure that the interest of the investor receiving countries is also protected, the people of the investor receiving countries, the environment in the country, the human rights situation in the country, the rights of workers working for these multinational corporations are protected. So, the current trend in international investment treaties, bilateral or regional treaties, has been to take into account developments taking place in other areas of public international law, in other areas of international law, in other areas of international economic activity, so that a bilateral investment treaty is balanced as possible, is able to provide protection needed for foreign investors, but at the same time takes care of the needs of the local population, of the population in the country where they have invested. Therefore, the role of bilateral investment treaties is a very important one to understand the regime of international investment protection. Thank you.